Mediation is a phenomenal tool, in my opinion, to try to settle a court case by keeping fees down and by customizing the agreement that works best for you and your family. With that said, the court isn't necessarily going to put you in a mediation on the front end of your case. It's likely the court will order you to mediate prior to your final trial, but it's not always required to mediate before you go to court at all. With that being said, if you and your co-parent or you and your spouse, generally speaking, think that an agreement can be made, a front-end mediation may be helpful to you and your family. Mediation is not necessarily what you see in the movies. We may not be sitting in a round table arguing over airline miles in one room. In a mediation, you're in a room with your attorney, your spouse or the other parent is in a room with their attorney if they have an attorney, and then the mediator, who is a neutral third party, bounces from room to room, trying to get something done. If an agreement is reached, the benefit of that agreement is it's drafted into what's called a mediated settlement agreement, or you'll hear me call it an MSA. If every party puts pen to paper on the MSA, that agreement is binding. In other words, you're entitled to a judgment based on that agreement. If you were to call me the next day and say, gosh, Turner, you know what? I thought about it and I don't want to do this mediation agreement anymore, unfortunately, there's nothing I can do. On the flip side of that, if you want to move forward with the final decree or final order based on that agreement, there's nothing that the other party can do to stop it. If you want to talk to me more about mediation, the mediation process, and whether or not that's a good fit for your family case, feel free to give me a call at 817-900-3220, and I will walk you through that process. Or you're welcome to contact us via our website at familytexas.com.